Hi, I am attorney Chris Bathan-lasco. This is my virtual classroom. Welcome to my YouTube channel. In this channel, I shall aim to simplify the law. I will discuss concepts and principles of law in under 10 minutes. And I will be discussing the second type of defective contracts, the voidable or annullable contracts. Okay, so let's begin. So the second type of defective contracts are your voidable contracts. So what are voidable contracts? These are contracts that are valid until it is annulled. Okay. Now, you look at 3090. It gives you the two types of voidable contracts. First, one where one of the parties is incapable of giving consent. Either he is a minor or he is insane or suffers any disability that will not enable him to give consent as defined by law. Which the second type of voidable contracts is where there is vitiation of consent, meaning there is mistake, there is violence, intimidation, undue influence, or fraud. So let's take, for example, A, who is a minor, enters into a contract with B. This falls under the first type of voidable contract because A is incapacitated to give consent. Now, what happens to the contract if both are incapacitated to give consent? Supposing B is also a minor. If you have read in advance already the third defective contract, the unenforceable contract, that will tell you that if both are incapable of giving consent, then it's no longer voidable, it is unenforceable. Another type of voidable contract is when the consent is vitiated by mistake, violence, intimidation, undue influence, or fraud. So, for example, A entered into a contract with B because B employed intimidation against A and forced A to sell his parcel of land to B because if he will not, then B will kill A's wife. That is intimidation. This makes the contract of sale voidable. Okay? Why not void? It's not void because there is still consent, only that it is a defective or a vitiated consent. If there was totally no consent, then that's a different story. It makes the contract void. So what are the characteristics of your voidable contract? So the first, you've already mentioned that it consists in the vitiation of consent of one of the contracting parties or one of the contracting parties being incapacitated to give consent. Second, they are also binding, and we've mentioned this already because they're valid until it is annulled by a competent court. Third, they are susceptible of convalidation by ratification or by prescription. So how different is annulment from rescission? We mentioned already in rescission, it is based on lesion or economic prejudice. In annulment, the basis is the vitiated consent or the incapacity to give consent. In rescission, since we're talking economic prejudice, the defect is external, meaning outside the contract. While in annulment, the defect is intrinsic. Why? Because it involves the elements of a contract. You look at the consent, which is one of the elements of the contract. Another difference is that in rescission, I've mentioned already in the last video lecture that it is subsidiary. In other words, you use that remedy of rescission only after you've exhausted all other legal remedies available to you. While in annulment, that action is principal and not subsidiary. Rescission is a remedy, while annulment is a sanction. Okay? Another is that private interest governs in rescission because, again, we're talking about financial or economic prejudice. While in annulment, it's the public interest that governs. Precisely, the law makes the contract voidable to protect an incapacitated person in entering into such contracts. In the same manner, it also gives a remedy to the injured party because his consent was vitiated. So, public interest governs. Another is that in rescission, equity predominates, while in annulment, law predominates. Another, in rescission, the plaintiff may be a party or a third person. Why do we say the plaintiff may be a third person to a contract? Because we said it is available also to creditors who are defrauded. Okay? While in annulment, the plaintiff must be a party to the contract, whether bound principally or subsidiarily. So a third person cannot file an action for annulment. Another difference is that in rescission, there must be damage to the plaintiff because, again, we are talking about economic prejudice. And in annulment, the damage to the plaintiff is immaterial. You may or may not prove damage for in asking for rescission, but that is immaterial in the action to ask for annulment. But if you're asking for damages, then of course you must prove that you have suffered damage. Another, in rescission, if plaintiff is indemnified, then the rescission cannot prosper because precisely rescission is there to erase the economic prejudice. And so, if prior to the rescission there was already indemnity, then you can no longer ask for rescission. In annulment, the indemnity here is no bar to the prosecution of the action. So even if you're indemnified, you can still file an action, unlike in rescission. In rescission also, it is completely compatible with a perfectly valid contract. Why? Because all the elements are there. They're all valid. The defect is not intrinsic. The defect is extrinsic. Again, that economic prejudice. While in annulment, there is a defect, and that is the consent. One of the elements of the contract is defective, and that is consent. Rescission, to prevent it, ratification is not required, while in annulment, to prevent it, ratification is required. Now, 1397 tells you who may institute the action for annulment. 1397 says, the action for the annulment of contracts may be instituted by all who are thereby obliged principally or subsidiarily. Again, must be a party to the contract, whether bound principally or subsidiarily. Persons who are capable cannot allege the incapacity of those with whom they contracted, nor can those who exerted intimidation, violence, or undue influence, or employed fraud or caused mistake, base their action upon these flaws of the contract. What does that mean? So let's go back to A and B. If A is the minor, okay, if A is the minor, then B, who is the one who is of legal age, cannot file an action to annul the contract and allege the incapacity of A. It shall be A, upon attaining capacity, will he be able to file an action to annul, or the guardian of A. And in the other example, if B was the one who employed intimidation and A's consent was vitiated, B also here, the guilty party, cannot file an action to annul, alleging the vitiated consent of A. In other words, it must be the innocent party or the incapacitated party who must file an action to annul. Or in the case of the incapacitated, once his incapacity ceases, or the guardian of the incapacitated person may file an action to annul. So, the person of legal age cannot file an action to annul alleging that the other is a minor. And the guilty party also cannot file an action to annul alleging that the other party was just forced due to a vice of consent. So that is what is meant by 1397. Now, may creditors of the innocent party ask for annulment? The answer is no. Why? Because a creditor of an injured party or an innocent party is not within those persons who are allowed by law to file an action for annulment, because the creditor is a third party. So again, let's go back to this. A forced B to enter into a contract with him. Okay, so B now is the one whose consent was vitiated. If B has a creditor, okay, if B has a creditor X, so X cannot file an action to annul the contract between A and B because he is a third party. Now, when you look at the case of Sing Song versus Isabella Sawmill, you will see there that he was a creditor, he's a third party, and yet the court allowed the filing of an action to annul the contract. I do not agree with this. Why? Because he is a third party and the law is very clear that third parties cannot file an action to annul. But of course, that does not mean that he does not have a remedy. He should have filed an action to rescind because that is available to third parties. But maybe the Supreme Court allowed it in this case because the effects actually of annulment and rescission are the same. It's mutual restitution. So at the end of the day, the effect is the same. But as to the propriety of the action, if we want to be correct in the action that we are filing, if you are a third person, you cannot file an action to annul. You may, however, look into another remedy, and that is the action to file for rescission. So what is the prescriptive period for filing an action to annul a contract? That's 1391. It says there that the action for annulment shall be brought within 4 years. But the 4 years, the question now is, when do we start counting the 4-year period? It says there, in cases of intimidation, violence, or undue influence from the time the defect of the consent ceases. So only when there's no more violence, there's no more intimidation, can you count the 4-year period? Because clearly, if you are still suffering from such vice, then the period will not start to run. Because then you would be afraid to file an action to annul the contract if you are still under those vices. Now, that's for violence and intimidation. Now, how about for mistake or fraud? For mistake or fraud, the 4-year period will be counted from the time of discovery. Because when you commit a mistake, then you will not know right away at the inception of the contract that you committed a mistake. So the 4-year period will come from the time of discovery. And for fraud also, clearly at the start of the contract, you're led to believe that what you are entering into was a perfectly valid contract. So the discovery may come only later. And so the 4-year period will come only, or rather will start only from discovery. Now, how about with respect to the first type of voidable contracts on when one of the persons are incapacitated to give consent? When will the 4-year period start? The 4-year period will start when the incapacity ceases. So, if a minor, then 4 years will start from the time that the person has attained majority. If, for example, insanity, then from the time that he becomes sane. As I mentioned also earlier on, the same effects as that with rescission. In annulment, there is also mutual restitution. Again, you return whatever you have received by virtue of the contract. That's the effect of annulment. So in 1398, it says, an obligation having been annulled, the contracting parties shall restore to each other the things which have been the subject matter of the contract, with their fruits and the price with its interest, except in cases provided for by law. But how about in obligations to render service? You clearly cannot return a service because once a service is done, you cannot undo it. The law says the value thereof shall be the basis for damages. Of course, if the an object of the contract is now in the hands of a third person, can you oblige him to restore? It depends. If the third person is innocent, then he is protected. He cannot be obliged to restore. But of course, if, just like in the discussion on rescission, if it is found that the third person is not innocent, then he may be obliged to restore. 1402, as long as one of the contracting parties does not restore what in virtue of the decree of annulment he is bound to return, the other cannot be compelled to comply with what is incumbent upon him. So, what does that mean? That if there is a decree of annulment and then you cannot restore, you cannot return. There's already a decree of annulment, but you cannot return because you have already sold it. And the third person is an innocent third person. You cannot ask him to give it back to you. So, in the same manner, the other party cannot also be obliged to return to you what he has received by virtue of that voidable contract. Now, 1399, it says, when the defect of the contract consists in the incapacity of one of the parties, the incapacitated person is not obliged to make any restitution except insofar as he has benefited by the thing or price received by. So if you are dealing with an incapacitated person, they are not obliged to restore you with whatever they have received unless they were benefited by it. And of course, you being the person capacitated, you have to prove that there was such a benefit. So for example, if you can prove that the money that was given to the minor, he used it to buy groceries, he used it to pay tuition, then there is a benefit and he may be obliged to restore. Because the law says insofar only, there's restitution only insofar as he has been benefited by the thing or price received by him. Okay? So 1400, whenever the person obliged by the decree of annulment to return the thing cannot do so because it has been lost through his fault, he shall return the fruits received in the value of the thing at the time of the loss with interest from the same date. So this again presupposes that there's already a decree of annulment. So the case has been done. There's already a decree of annulment. The court already orders the parties to return. Whatever they have received by virtue of the contract, they have to return to the other contracting party. Now, what if you cannot return? And you cannot return due to your fault. You may have destroyed it. You lost the case, and so you were angry. You destroyed the thing. What now will you return? The law says you will have to return the fruits received and the value of the thing at the time of the loss with interest from the C date. 1401. The action for annulment of contracts shall be extinguished when the thing which is the object thereof is lost through the fraud or fault of the person who has a right to institute the proceedings. What does it mean? It means that if the object to be returned by the other party, okay, by the guilty party, okay, is lost due to the fault of the innocent party, he is the reason for the loss, then his remedy now to ask for annulment cannot be had. That's what is meant by action for annulment shall be extinguished. Because you can no longer ask for annulment and ask that the thing be restored to you being the innocent party, if you were the reason for the loss. The second paragraph talks about incapacity. If the right of action is based upon the incapacity of any one of the contracting parties, the loss of the thing shall not be an obstacle to the success of the action unless said loss took place through the fraud or fault of the plaintiff. So just to say, even if the thing is lost, okay, it will not stop the plaintiff from filing suit unless it was his fault that the object or the thing is lost. Now, we mentioned earlier that you can ratify a voidable contract. So what are the requisites for ratification? Of course, under this chapter, the contract must be voidable. Second, the ratification is made with knowledge of the cause for nullity, because you cannot cure the defect if you do not know what the defect was. Third, at the time of the ratification, the cause of nullity has already ceased to exist. So, for example, there was fraud employed. Okay? You now know that there was fraud employed. to entice you to enter into the contract. Can you ratify it? Yes, you can ratify it if you know that there is fraud and you know exactly what fraud was committed against you. Okay? And also, that's when you can ratify it. How about violence? Okay? You can ratify a voidable contract when there was violence employed upon you if there was no longer any violence at the time. Or if there was intimidation employed against you, again, you can ratify it if you know that you were intimidated. At the same time, it has already ceased. That defect is no longer there. It no longer exists. So that's when you are able to ratify, when the cause of the nullity has already ceased to exist. Fourth, the ratification must have been made expressly or by an act implying a waiver of the action to annul. Meaning, ratification may be expressed or implied. And, of course, the person ratifying must be the injured party. So that's 1393. 1393 tells you that ratification may be expressed or implied. It may be effected expressly or tacitly. What do you mean by tacit ratification? It is understood that there is a tacit ratification if, with knowledge of the reason which renders the contract voidable, and such reason having ceased, the person who has a right to invoke it should execute an act which necessarily implies an intention to waive his right. So actually, that's the case of Oisulim versus Tan Unshuan. So here, he wanted to file an action to annul the contract of sale, saying that he was a minor then, but he actually used the substantial amount of the proceeds. So that is ratification. So for example, here, A forces B to sell his particular parcel of land by pointing a gun at B. Okay? So B was forced to sell his land to A, and A paid him. Now, after B was paid, clearly there's vitiated consent because he would not have sold it had A not pointed a gun at him. But if after receiving the money, B goes shopping, B goes on a vacation, this is the money and benefits him, that is tacit ratification. And if there's ratification, then the remedy of the action for annulment is no longer available to you. That's 1393. 1394, as we mentioned earlier on, if a guardian of an incapacitated person can file an action to annul, in the same manner, the guardian can also ratify the contract entered into by an incapacitated person. That's 1394. Ratification may be effected by the guardian of the incapacitated person. Now, in ratification, do we need the conformity of the guilty party? Like, for example, in our example earlier, A pointed a gun at B and forced B to sell his land to A. Okay? Now, if B ratifies it, does B need the consent of A for the ratification? Of course not. That is 1395. Ratification does not require the conformity of the contracting party who has no right to bring the action for annulment. Why? Because if we will allow that, if we will require the conformity of A, then you are now giving A the chance to back out, when in fact he was the reason why there was this contract. So as a punishment, if B wants to make this contract valid, then he has no choice but to abide by it. Okay? And of course, what's the effect of ratification? It extinguishes the action to annul a voidable contract. And of course, it cleanses the defect of the voidable contract. That's 1396. It cleanses the contract from all its defects from the moment it was constituted. So that ends your the chapter on voidable or annullable contracts. So if you find this video helpful, please click like, subscribe, and that notification bell so that you will be notified of new video uploads. Thank you for watching. See you next time in MBL Classroom.